Hi, everyone, and welcome to Symptai's virtual open day for the Jamaica Data Protection Act. We've been having a lot of conversations about the JDPA and the impending full implementation on December 1. And we wanted to bring everybody into this conversation space around just what people are doing in anticipation for that full implementation. My name is Andre Palmer. I'm going to be the host of this live virtual open day. I am the Director of Strategic Client Engagement at Symptai Consulting. And joining me for this conversation is Daniel Monroe. He is the Manager for Special Projects here at Symptai Consulting and a lead consultant in the Data Privacy Compliance Unit. Daniel, thank you for joining me. Good morning.
Thank you for having me. Good morning.
Let's talk a little bit about the Jamaica Data Protection Act. So we've been talking about this for a couple of years, but let's assume that a number of people who've joined this webinar today are completely new to the conversation. In a nutshell, what is the Jamaica Data Protection Act?
Quite simply, the Jamaica Data Protection Act is a relatively new legislation that provides some rights to individuals about their data. It also provides some requirements and guidance for companies on how they can lawfully and fairly acquire and utilize that data or process that data within the rights of the individual. It also outlines, of course, some fines and penalties should companies not adhere to the regulation, the laws outlined. Yeah.
And why is this important? So we've seen data privacy and data protection legislations in other jurisdictions. And the most notable is probably the GDPR, which is the General Data Protection Regulation coming out of the EU. And a number of other jurisdictions have followed suit. So why is this important? Why is it necessary?
Well, data has become such a massive asset to organizations and even to the development of countries. We can see where data can be used to affect public opinion. It can affect your ability to access various services, not just in the public sector, but also in the private sector. It can affect various persons in different ways. And so it's not a new conversation. It has been in existence. I think it started in the 70s for the EU. And the concept of developing privacy around individuals and the information about them started back then. The GDPR came into effect in 2016. In Europe, and it had a worldwide effect for not just companies and individuals inside the EU at the time, or they're just their citizens, but anyone that is currently inside the EU. So if you are a tourist visiting EU, the rights there protect you and your information while you're there. It also protects their citizens while they're outside of the EU. It also has provisions on how companies can share information to other companies, especially across borders. So if I have one entity here in Jamaica and I have another entity in Spain, then how do I share information across these borders? If I am doing a partnership with another company that exists in Ireland or Germany, and so it's not a company that is on my under my structure or my payroll. We're doing some sort of business partnership and we're sharing that information. How can we do that with the rights of the individual in mind, protecting that information appropriately from any type of cybersecurity threats, and ensuring that this information, when it gets to the other entity, that it is accurate and represents a person appropriately within their rights as well.
Yeah, and great context. And as you were talking, I was reminded of the high-profile data breaches with companies like Facebook and Google and Instagram, and we know all about those too well. But I'm sure that a number of people on this particular webinar have been victim to either a data breach of some sort, you've gotten unsolicited emails, you've gotten text messages from companies that you've not provided your text message, your mobile number to. You've gotten emails from companies promoting products and you've not made your email address available to those people. You've not given consent. So the law, as Daniel was describing, is intended to protect you, the data subject, and the way in which your data is being used. In as much as you and your organization now need to be mindful about how you protect the information that is in your custody and how you use that information or that data responsibly. So as we're talking about how organizations protect the data that is in their custody, I'd love to switch gears now to some common malpractices that as a consultant, you have either experienced or observed when you go into organizations to work on data privacy engagements.
Okay, great. Well, the most common malpractice or issue that occurs is that at times, you're sending an attachment, you're sending some sort of email to a team of persons, you're quickly smashing in those email addresses, and you're just pressing enter, clicking on the first thing that pops up from the autofill. And at times it's the wrong email address, or possibly even somebody's private email address instead of their company email address. And so you're sending correct company information, but to the wrong recipient, to the wrong person, which could include, it could be the right person, but their wrong email address. So it's now outside of the company's email server or even another company email server. So it's outside of any company's handling. And so that counts as disclosure and exposure of somebody's information. So that's a very, very common issue happening across the world, not just in Jamaica.
Yeah, that's an interesting one. Yeah, sorry, go ahead.
No problem. Some other issues could be, that sounds at a company level, but something that could happen at a person level within the company is, for example, simply leaving your screen, your computer unlocked, and the person's passing through the office that should not be able to see particular details of information. And you can think, oh, well, what could somebody see? Well, imagine going to HR to deal with that issue. You're walking past the payroll officer's desk and you're seeing person's payroll information on the screen because that person was processing payroll that day. There's also situations where companies may have a bring your own device kind of setup within their organization, or even company issued devices, and they're using it for personal things as well as the company things. So there's corporate data, there's individuals' data on the device, but you're also, using it for your own personal, at home, especially during COVID, work from home, persons were using it for school, for their children, for their day-to-day, online browsing and things like that. And so there was a potential of exposing what's on that laptop to viruses, to hacking attempts, to other persons using the laptop that shouldn't be able to see this information.
Interesting. So as you're talking, Daniel, it occurs to me that data is so vast and there is a lot of data out there that people are processing every day. When I go to a company, for example, to do business, I may be asked to write my name in a sign-in, a login book at the reception. Yes. I may, my first name, my surname, my signature, my license plate number, in some cases, the person I'm going to, and why I'm visiting.
Sometimes a phone number as well. Yeah.
Sometimes a phone number as well, and all of that stuff. So break down for us the type of data or the types of data that the Jamaica Data Protection Act is concerned about. Is it all data? Or when we say personal data, what exactly do we mean?
Well, under the JDP, the Jamaica Data Protection Act, it covers two main categories: personal data, which covers any type of information that can identify someone as an individual, or sensitive personal data, which is a set of categories that is considered sensitive to a person's well-being. So, for example, their medical health, their political affiliations, religious affiliations, and so on. Trade membership, trade union membership, that is, sexual orientation, and other category items like that. Yeah. But for an example of the personal data ones, it's name, address, phone number, email address, social media handles, employee ID numbers, credit card information, your financial transactions, because that can give you a history of someone's behavior. So having a history of someone's behavior, you can know their pattern, their daily patterns, and so on. So things like that would be considered personal data. And there are, just to know, there are clauses within the Act that specifies additional steps for handling personal data, sensitive personal data for children and for persons with disabilities.
Yeah, and the Jamaica Data Protection Act, the online course that is being offered by Symptai, goes into all of this in great detail. So it talks about the intention of the Act, gives a little bit of an overview. It also goes into detail about the classification of specific data that is being protected within the Act as well. So, but we just wanted to have this conversation so that participants can understand in a very real way what the Act is trying to do and the types of data it is intended to protect. I want to come back to a question or to something that you've raised earlier, Daniel, and it is really around the examples of some malpractices within organizations. So listening in, it is very easy for somebody to assume that the responsibility of protecting an individual's personal data resides with the company. But who makes up the company? Whose responsibility is it to protect the data?
Yes, because the Act does have fines and sentences, jail sentences for individuals who are deemed responsible. There are cases where if it's the company on a whole being seen as negligent, it could be persons on the executive level, directors, CEOs, that could be fined and potential jail time for these offenses. If it is found to be something committed by a particular individual within a company, say, for example, you had a malicious actor or somebody that, a corporate espionage type of situation where somebody was working at a company and intentionally taking and sharing data to someone else for, outside of the company's legitimate processing or purposes or actions, right? Or their policy and processes, right? And that person was taking the information and selling it, for example, to an illegal entity there, right? That person that has been found to be doing that illegal activity could then be fined and charged. And the fines range from $1 million to $5 million. There are many $2 million fines in there. And if the company on a whole is found negligent, the company can be fined 4% of their gross worldwide revenue or turnover, as the law says, for the previous financial year. So that's your gross revenue being fined 4%, not your income after tax or EBITDA or anything like that, or after net profit margin, gross.
Yeah. So that's interesting. So we're hearing about the consequences, and we're seeing that in addition to the financial penalties, there is also the possibility of prison sentences, as long as up to 10 years in some cases. And we haven't even started to talk about the reputational damage that the organization might suffer as well, and then some of the other consequences that may also result as well. A part of what I am hearing too is that data protection is everybody's business. It's not just the role of the data protection officer. It's not just the role of the CEO. It's not just the responsibility of legal and compliance, but everybody within the organization, from the security guard all the way up to C-level. Because once you are involved with the collection, processing, storage, sharing, analysis or deletion of data, you have a responsibility to also be part of the chain of protection within that data lifecycle. So having said that, what I want to do is quickly segue to how the Jamaica Data Protection Act online course, the short course, helps companies and individuals to understand their responsibilities under the law and also to protect the assets that they are custodians of.
At the end of this course, you will understand why it has become necessary for countries across the globe to consider the implementation of data protection laws. We will walk through the major tenets of the law and, where appropriate, outline the implications to individuals who collect, store, and process personal data. Knowing the law is one thing, but understanding what it means for your organization is important and what you can do about it. Due to advancement in technological innovation, information privacy is becoming complex by the minute as more data is being collected and exchanged. As the technology gets more sophisticated, indeed invasive, so does the use of data. Data has become the lifeblood of many organizations, whether it is assisting in making business decisions, increasing profits, enhancing products and services, or controlling outcomes. Processing data can impact persons who are the subjects of this data. Not all processing has a positive impact. Irresponsible processing of data can cause significant harm or even death to the data subject and/or related parties. This issue leaves organizations facing a complex risk matrix for ensuring that personal data is protected and processing it does not have a negative impact on the data subject. Personal data, or personally identifiable information, PII, refers to information belonging to a natural person. A natural person is an individual as opposed to a corporate body that sometimes takes on a persona. Jamaica's data protection law seeks to protect the personal data of living individuals and those who have been deceased for up to 30 years. Module 2 deals with the rights of data subjects and others. By definition, a data subject is a named or otherwise identifiable individual who is a subject of personal data. And in determining whether an individual is identifiable, account shall be taken of all means used or reasonably likely to be used by the data controller or any other person to identify the individual, such as reference to an identification number or other identifying characteristics, whether physical, social, or otherwise.
If controllers are not compliant with registration requirements, they must prove that they have done their due diligence. Failure to prove due diligence shall be liable under conviction to a fine of up to 2 million Jamaican dollars or imprisonment up to 6 months. In addition to these fines, processing that may cause substantial damage or substantial distress or otherwise significantly prejudice the rights and freedoms of data subjects may attract a fine not exceeding 5 million Jamaican dollars or imprisonment for a period not exceeding 5 years. A data protection officer advises an organization on how to ensure compliance with data protection regulations. The officer must have deep involvement in all data protection matters. They should guide data subjects in understanding their rights and how to demonstrate with respect the Act. They should ensure that the data controller processes personal data specific to the provisions of the Data Protection Act and in adherence to data protection standards. They should consult with the Commissioner to resolve misunderstandings and uncertainties in the execution of the Act and any other prescribed regulation. However, the Data Protection Officer should hold the data controller accountable for violating data protection standards or the tenets of the Act by first notifying the controller of the violation in writing and subsequently reporting any such breaches to the Commissioner if the controller has not appropriately remedied the situation.
But I hope that you got a little flavor of what the course entails. Talks about the rights of the data subjects, it talks about processing standards, talks about the responsibilities of the organizations, it talks about the roles and responsibilities of the data protection officer, Which brings me to a question that was actually dropped in the chat by Donald Smith. Donald asked a question. He says, in terms of reporting of breaches, is it the DPO who has responsibility to make reports to the OIC, which is the Office of the Information Commissioner, or is it the data controller? Also, are there any instances covered under the Act where breaches don't have to be reported? So good news, Donald, all of that is actually covered in the short course. But I'm going to ask Daniel just to respond to the first question, which is around who is responsible for reporting the breach. Is it the DPO who is responsible, or is it the data controller? So perhaps, Daniel, you could start with just explaining who the DPO is and who the data controller is, and then you could talk about who is responsible.
Sure. Okay, so the data controller is the corporate entity that one is registered with the Office of the Information Commissioner. So if you're not registered, you can be in violation of the Act if you are found to be processing information, personal information data, right? So the data controller is the entity that essentially makes the decision about the data. You may not be the entity that is collecting the data. You may not even be the entity that is processing the data, because outsourcing has become a massive reality worldwide, including in Jamaica, all right? But if you are the entity that is making the decision about it, then you are the data controller. Even if you've outsourced service, your HR, your payroll, whatever services, right? The data protection officer, on the other hand, is somebody employed to the data controller, right, who has a responsibility similar to like an internal auditing function, where you are providing guidance to the organization about the Act. You are a point of contact for data subjects in all matters Privacy or Data Protection Act related to the company, right? And you assist the company ensuring that by making providing guidance and so on in regards to developing their organizational measures, possibly even their technical measures. The data protection officer also has a duty to at times do an internal assessment of your technical and organizational measures and provide feedback to the organization in terms of what is the Act is requiring, what's good data protection practices, standards and practices, and so on for your technical services, products, your operations, and of course for the organizational policies, procedures, practices in the organization. To answer the question, if who reports to the commissioner, the DPO would advise the data controller to report to the commissioner initially. And if it's a case where the company, the data controller has not done so within the appropriate time frame, the DPO escalates the issue to the Information Commissioner. Okay, so if there are some aspects of the Act that require the data controller, the company, to report an issue to the regulator, to the Information Commissioner within 72 hours, in some cases 48 hours, and if that is not done or done satisfactorily, the DPO has a right to escalate the matter to the regulator.
Okay, great. Thank you, Daniel. And it's a point to note too, which the short course goes into. The data protection officer can also be somebody else external to the organization. Yes. So what we're seeing a lot of organizations doing now is they're outsourcing the function of the DPO, simply because the DPO is almost a whistleblower. If you think of how a whistleblower operates within an entity, they are responsible for identifying and highlighting the any instances of breach. Now, whenever this happens, that particular individual can actually be blackballed, they can be signed, there can be issues of I guess, unfair treatment as a result of them reporting the organization to the Office of the Information Commissioner. So for that reason, a number of organizations are choosing to keep the function separate, and they're engaging external partners, external entities, or external individuals to act in the capacity of DPO, and that is generally called Data Protection Officer, as a service or an external data protection officer. So the law does not stipulate that the DPO has to be someone within the organization. The short course goes into the role of the DPO in a lot more detail. It also talks about the functions, the reporting functions of the DPO as well in a lot more detail. Again, feel free to put your questions in either in the chat or in the Q&A segment, and we will respond to as many of them as possible. There's a question, Daniel, from Robert Gilbert. He says, based on the overall definition of the Jamaica DPA, what are some differences from the GDPR? And if an organization is already following GDPR guidelines, what would they need to do to be considered in alignment with the Jamaica DPA? That's a very good question, Robert.
Yes. And thanks, Robert. Okay, so firstly, to review the rights of the data subject, there are some similarities there in regards to between JDPA and GDPR. One of the main ones is that the Jamaica Data Protection Act requires consent specifically for direct marketing, where the GDPR does not require that. It just has a blanket consent statement. And so organizations in Jamaica that are conducting direct marketing kind of activities must get consent from individuals to be able to use that kind of marketing with them. Another difference is that GDPR provides a facility or a right for to be forgotten or erased from a database from a company, of course, with some limitations there. So if there is no contractual requirement or other requirement blocking or requiring the company to keep the data, right, a person can request to be forgotten or erased from a system in Europe. So I can go to the bank if I have no other business with them and say, hey, I'm not using your services, I'm not using your products, I don't want my money here. So I have removed it and I now want to be forgotten. The entity has a time period that they have to respond to it and remove that person from their systems within any time frame that they are legally allowed to. Because of course there might be other legal obligations, criminal investigations, fraud, other requirements under banking regulations and so on, in that example. Another difference, if I'm remembering correctly right now, is in regards to, that's actually the same, transferring of information. There's a requirement for the information to be in a format that is acceptable between the organizations. It must be a standardized format. It can't be something that's arbitrary, not commonly used type of format. Yeah. The fines, of course, are different as well. In terms of obligations for companies, they are actually very similar. Yes. Yeah. So the main places where it is different between the acts are the data subject rights.
Yeah, excellent. So, and it is instructive to point out that the Jamaica Data Protection Act, like a lot of the other data protection regulations in other jurisdictions, have been modeled on the GDPR because they came after, and also because the GDPR is by far the most far-reaching piece of legislation and the most comprehensive around data protection and data privacy. So you'll find a lot of similarities in the Jamaica Data Protection Act as well as in the GDPR. The short course goes into some of those in the beginning as well. All right, great. Thank you, Daniel. A question in from Stephen Williams. He says, does the Jamaica Data Protection Act state what type of organizations should register And does the Act have accompanying regulations as yet?
Okay, I'll answer the second one first. The regulations are still being developed and will be made available shortly based on the feedback we've gotten from the Office of the Information Commissioner. Yes, the Act does have some statements in there regarding the type of organization, but in a blanket case, it's once you're processing personal data. The other statement is that if you're processing a large amount of data, which the regulations need to address, it needs to define what that means by large. There are exemptions, for example, religious entities, non-profit organizations. But once you satisfy the requirement for large, which, as I said, we need to get that definition for, you may still have to register, even if you technically count as one of these exempted entities.
Great. And about the regulations, I know those have been tabled. There are some draft regulations, but they have not yet been made, or they've not been ratified. So the regulations are considered still in development so while there is a set of draft regulations, they have not been ratified. A question from
section. Sorry. It said that would the 30 years of protection for deceased persons. It considers a person that has deceased up to 30 years ago as an individual. So if the data identify that deceased person up to 30 years, the Act still protects that person. And that's because there may be cases before the court for estate disbursement or wills and testament, things like that may still be billed. And so the protections have to be there for that type of individual. Yeah.
All right, great. A question from Natasha. She says, if I am a marketing manager, should I be looking at doing this course? Do I have to be aware of the Data Protection Act? I mean, does it affect my marketing activities?
Yes, I would definitely recommend this course for marketing persons, and I would recommend all marketing persons to get familiar with the Act. Marketing is a very personal type of activity. You are trying to reach out to customers and bring them into the organization. And so marketing may handle personal data for individuals from various activities. So you are bringing in data into the organization to be able to reach out to these persons. You are accessing information that a company already has to be able to identify what may be beneficial to these existing customers. What can you extend to them to keep them as customers or spread them across your products and services. And so I think it's very important that marketing does this course or at least get familiar with the Act. As I said earlier, there is a requirement for direct marketing, for consent for direct marketing in the Act. There are considerations for minors and for persons with disabilities as well. And so it's important to understand these aspects for marketing and processing their data for direct marketing.
Great. And if I could just add a little bit to what you said there, Daniel. In module 2 of the course, when it really goes into the rights of the data subjects, you will realize that there is a lot of room for marketing to make mistakes if we do not observe the rights of the data subjects. So when we talk about the right to give consent to direct marketing, and earlier in the conversation, I talked about the fact that many of us in this webinar have been victims of receiving unsolicited emails, unsolicited text messages, unsolicited calls. And usually those tend to be a function of the marketing department. So it's easy to see how marketing can fall prey to a lot of the breaches that will occur if not careful. So we do recommend highly that marketing managers, marketing executives, people in marketing positions take this course because of the focus on the rights of the data subjects and the responsibilities of data controllers. So it helps you as marketers to execute your duties more effectively. Another question, we just have a couple of minutes to go, so we'll try to get through these last set of questions. Dane Peck asks, is it a must for each processing organization to have a data controller and data protection officer? And B, can the data controller and the data protection officer be the same person? And that was why I asked you to make the distinction, Daniel, about the data controller and the data protection officer, because it's a common mistake to make. But if you want to respond to that quickly.
Okay, so just to clarify, the data controller is the organization. So once you are an organization that is collecting, using, processing, sharing personal data in any way, shape, or form, that entity is considered a data controller, because you control what happens with that data. And it's recommended that you have a data protection officer, because they will interface between the organization, the Office of the Information Commissioner, and the data subjects themselves. They will guide you on what is legally required, what needs to be done, reporting. They will assess you, your products, your services, your processes for issues, and guide you, not to report you, but to guide you on how to address those issues. And yes, there is an obligation. If you do not address an issue that could cause potential harm and you haven't addressed it within a satisfactory time, they may report. Or if there's a breach, they may report if you do not do it within a sufficient time frame.
Okay, great.
Yeah. So hopefully that answers both parts. Yeah.
Right. Another question, is the course accessible for persons with disabilities? The answer is yes. So as you would have heard in bits of the demo earlier, you didn't get to, I guess, experience the full value of the course just now. But yes, there is a voiceover component. So all of the information that is contained within the e-learning platform is actually recorded. So it is actually accessible for persons with certain types of disabilities.
Yeah.
Is the answer to that. Question from Mervyn: are there categories of workers in and there's also the possibility of closed caption and using headphones as well too. So there is also that possibility within the course.
Yes.
Mervyn Hudson says, are there categories of workers in organizations that you would recommend doing this course? The answer to that, Mervyn, is like you said earlier, this is everybody's responsibility. So the course has been designed for every person within the organization, from the security guard, the receptionist, all the way up to members of the board of directors, just because there are so many touch points within the data lifecycle, people who are collecting information, people who are processing information, analyzing information, storing information, sharing information, and then destroying information, personal data. So the recommendation is that everybody within the organization becomes, at a basic level, becomes aware of what the law requires of them and their responsibility in the data protection life cycle.
Yeah. And just to add to it, because I know it looks so monolithic when you say everybody. As a company, you can prioritize your key persons first and eventually get to everybody. So you can target your customer service, your marketing. And just to give the reason why Andre says security guards, you might be thinking, but the security guard doesn't do anything. A lot of companies have a logbook when you come in. You have to sign your name, your signature, sometimes your email and phone number, sometimes who you're going to and why you're going to them, right? Whose property is that book? Is that a property of your organization, or is it the security company that you've hired? Does somebody at the security company have access to this information? Where are these stored? Things like that. So these considerations are important for everybody as best as possible. Even the janitor passing through an office and you have things on your desk, your screen is unlocked, persons are seeing person's personal information. These persons have to understand that, no, okay, you have to be careful with these kinds of things, because if for some reason this information gets out, who is to be blamed for something like this, all right?
And just to note too, for organizations that are looking to do enrollment for their entire staff, there is a separate registration and enrollment package available. So if you are an organization looking to put through your entire workforce on this particular course, do reach out to us at training@symptai.com or directly to me, Andre_Palmer@symptai.com. And we will be in touch around special rates that are available for group bookings as well. Another question, and we'll certainly, and do appreciate that we're 3 minutes over. So let's just get through these two as quickly as possible. How will penalty for a data breach be determined for government ministries? So government ministries are also governed in the same way as other organizations. So there will be no special treatment for government ministry in the event of a data breach or a data leak. So the same fines and penalties that are listed in the Act will be applied to government ministries as equally as they will be applied to companies within the private sectors. So there is no distinction about whether you are in public sector or private sector. The application of the fines and penalties will be this across the board. And then Patrick Brown has asked, will a copy of this program be made available at the end? If so, how does one acquire say? I believe this will be posted on our YouTube page. So you can go back to our page and check a little bit later today or later this week. And Eleanor Henry, hi, Eleanor. She's asked, what are the implications for security guards at housing complexes who collect the vehicle numbers and names of persons accessing and leaving the property? Really interesting one. Daniel, do you want to respond to that one?
Okay, thanks. It's similar to what I was saying earlier about persons coming to a company. They're collecting plates, names, apartment numbers, time in and time out, things like this. And it has to be decided who's in control of this data, who's deciding on this type of procedure to make this decision about its implementation, and then who controls what happens to this data afterwards. And therefore, there may be some data protection requirements there, because as you can imagine, within the span of a year, there may be hundreds of thousands of persons passing through a property, and that could be considered a large amount of data, right? And so you may, I don't know if it's maybe the strata entity that manages the operations of the property, depends on how you have that relationship with the security company. If it's their requirement and they're deciding on it, maybe they have to cover that exposure as the controller. But considering that it is the strata or the apartment complex that hires the security company and tells them that you need to do this process, I would say at this point, from just this simple example, that it would be the apartment complex.
Great, and that was why we kind of emphasized earlier that data protection is everybody's business. It can't just be the business of the CEO or the managing director or the executive director or legal and compliance. But because so many people are involved in the data life cycle, whether it is the collecting, as the security guard, as we saw in the case of that particular question, processing, storing, sharing, and ultimately destroying. A janitor that comes in at the end of the workday and destroys and shreds paper, if not done properly, can make the organization susceptible to data breaches. Imagine in a banking organization where a janitor comes in and just takes stacks of papers and throw that into the bin, and it ends up in the wrong hands. So it is important that everybody in the organization is seen as an equal part of the data privacy protection program. And that is why the Jamaica Data Protection Act short course that's been developed by Symptai has been designed for every person at every single level within the organization. Again, feel free to connect with us if you require more information. There are some bits of information on screen that you can access to get in touch with us. Feel free, if you require additional information, to reach out. Thank you so much for joining us. As always, I always feel like the time that we have is not enough. But we will be doing another one of these next week. So if you want a little bit more information, feel free to join us again then. But in the meantime, thank you so much, Daniel. Thank you so much for being with me for this live session today.
Thanks for having me.
Bye, everybody.